Once again, welcome to Young Legal Minds. This video will be on stage 3 of answering a misrepresentation problem question. We've gone over so far what a misrepresentation is. I've distinguished between a term and a representation. I have gone over an actionable misrepresentation, so false statement of fact that induced the other party into the contract. And now we're going to move on to stage 3, identifying the type of misrepresentation. This is important because it can determine the remedy that the claimant seeks to receive. So, at the common law level, there is fraudulent misrepresentation, which is also known as the tort of deceit, a negligent misstatement. And then there is the Misrepresentation Act 1967, which covers negligent misrepresentation. Now, as an important note, make sure you do not get confused between negligent misstatement and negligent misrepresentation. One is at common law, that's the former, and the latter, which is negligent misrepresentation, derives from statute. You don't want to get confused. They do sound similar, but they are entirely different. So the first one I will cover is fraudulent misrepresentation. Now, if the claimant seeks to receive a remedy under fraudulent misrepresentation, then the claimant must establish that fraud had occurred, and this is done using the test of dishonesty, which derives from the case of Derry and Peake, which essentially says that the representation is fraudulent if it was made, if the representor made it knowingly or without belief in truth, or recklessly careless as to whether it be true or false. So in other words, there are 3 situations where fraudulent misrepresentation can occur. The first one is if the representor knows that the representation being made is false, if it's fraudulent. The second one is that he doesn't truly believe what he's saying. It may be a partial truth. He may not know. He may be guessing himself, but that guess may be to carry out a fraud. Or he could be recklessly careless, which means he could have, I don't know, miscalculated or misjudged through carelessness as to what as to the fact. The next type of misrepresentation I'm going over is negligent misstatement. And negligent misstatement is based on tortious principles. So essentially there must be a duty of care with sufficient proximity, and that duty must be breached by the representor, and a breach will occur when that representor falls below the reasonable standard of care and skill expected, objectively expected. So there must be proximity, as shown in the case of Caparo, and to truly understand this principle, you can take a look at the case of Headley-Byrne. In the case of Headley-Byrne, the plaintiff asked their bank for advice on the financial position of a company. They asked them to inquire into the company's financial position, so that the plaintiffs would know whether or not they should invest into this company. Because if it's financially unstable, then they wouldn't have invested. But the bank gave incorrect advice to the plaintiffs. They told the plaintiffs that the company was doing well financially, that it was financially strong. But this was an incorrect statement, and the company went into liquidation, and the plaintiffs lost a lot of money as a result. The bank was, however, not liable, and the reason being was because of a disclaimer. And had it not been for that disclaimer, then the advice, the negligent advice, would have amounted to a statement made in negligence. So this is the case which really establishes that there must be a duty of care, sufficient proximity, and that the representor fell below the reasonable standard of care. all three of these were satisfied. There had been a duty of care, there had been sufficient proximity, and the representor, the bank, had fell below the reasonable standard of care. The only reason they were not liable was because of the disclaimer. And it also shows that the duty of care is determined by the relationship between the parties. So the bank owed a duty to the plaintiff because their actions would have directly affected the decision of the plaintiffs, which it did. There are a few reasons why a person may want to claim for a remedy under negligent Anyway, there are reasons why a person may want to claim for a remedy under negligent misstatement. The reason being is that it has a fairly wide scope. This is because it covers both incorrect advice and it also covers opinions. And this is because it's based on tortious principles. So all that really needs to be proved is that there was a breach of a duty that was owed to the claimant. And the Misrepresentation Act doesn't cover opinions. So if a statement was held to be an opinion and not a fact, then the act cannot be relied upon. And that is why in some circumstances a person may want to claim for a remedy on the negligent misstatement. That's one of the advantages. Right then, now moving on to the Misrepresentation Act 1967. Under the Misrep Act, if a claimant can prove that an actionable misrepresentation had occurred, so for a false statement of fact that induced him into the contract, then there'll be a presumption under Section 2, subsection 1 of that Act that the defendant was negligent. It's quite ironic because you'd think in contracts that the burden of proof would be on the claimant, but here the burden of proof switches from the claimant to the defendant. So, and you'll understand why in a moment. So, yeah, and if the claimant does that, then there'll actually be, if the claimant actually proves that there was an actionable misrepresentation, there'll be no need for the claimant to actually prove any negligence, which is an advantage to claimants because it means that there's a low threshold for the burden of proof. It means that all a claimant has to prove is a false statement of fact and inducement, which will probably be easier than proving negligence. So once the claimant has proved that there's an actionable misrepresentation, the burden of proof then shifts to the defendant, who then has to disprove negligence by proving that he had she had reasonable belief in the truth of the statement. And if the defendant cannot prove that they had reasonable belief in the truth of the statement, then the statement will be construed as a negligent misrepresentation. It's important to understand that the court take a very strict approach to this reasonable belief in truth, as shown in the case of Howard Marine and dredging, where the representor represented that the barge had the capacity to hold 1,600 tons of something, I don't know. But that was representation. The representation was that this barge could hold 1,600 tons, and they based that statement off of the fact that a previous barge they had dealt with could hold around the same amount. And it turned out that this barge could only hold 1,000 tons. And the court held that this didn't disprove negligence because they may have believed it, but it wasn't reasonable. They should have checked the specifications of the barge on the documents that came with it. So it must be more than just an educated guess. Just as a side note, but an important one, if the statement was held to be an opinion, then the claimant will want to pursue common law for negligent misstatement. The reason being is because this is only based on tortious principles, i.e. a duty of care, a breach of that duty, etc. An opinion does not form an actionable misrepresentation and thus will not come under the scope of the 1967 Misrepresentation Act, which requires for the claimant to prove the existence of an actionable misrepresentation. So if a statement was declared to be an opinion, then the claimant will want to pursue a common law for negligent misstatement. If the statement made was as to future intention, then it must be established that the statement was made fraudulently. It was, in other words, not intended to be acted upon, and so it will be better for claimants to claim under fraudulent misrepresentation where a statement of future intention had been made, given that it was fraudulent. Because common law under the Misrepresentation Act 1967, the claimant has to establish the elements of an actionable misrepresentation, which may be harder to do if it's based on future intention. But if the claimant can prove that the statement of future intention was fraudulent, then there should be no reason why he cannot rely on the Misrepresentation Act 1967. But generally, if the statement was of future intention, then they would want to pursue a common law under fraudulent misrep, simply because statements of future intention aren't always likely to amount to a actionable misrepresentation. Furthermore, if the defendant does manage to disprove negligence or fraudulence under Section 2, subsection 1 of the Misrepresentation Act 1967, then the court can still make a remedy for innocent representation, which essentially means that the statement was not fraudulent or negligent. So that's part 3 on answering a misrepresentation question. So we have gone over how to distinguish between a term and a representation. We have gone over an actionable misrepresentation, and we have now gone over the type of misrepresentation. And in the next video, stage 4, we'll be going over remedies and damages, and then that will be the final series. That will be the final episode of this series of presentations on misrepresentation.